Okay, the issue of trespassers in South Africa has, over recent years, become quite a worrisome problem for ship owners and their P&I clubs. And it has, in fact, painted South African ports in a fairly bad light. It's an issue that is particularly prevalent at Durban, but it's also quite relevant in Cape Town and PE. It's quite a multifaceted issue, but let's start with recognizing that government's role in restricting access to our borders is a very necessary one, and the rationale behind it is quite clear. Unpacking that, there are two scenarios in particular I'd like to touch on today within the context of shipping. So we'll call that scenario A and scenario B. Scenario A envisages a situation where a ship owner unwittingly brings a foreigner into the country illegally on board his or her ship. That's commonly referred to as a stowaway. The legislation refers to such an individual as an illegal foreigner, and I'll unpack that a bit later. That's scenario A. In scenario A, I think as a South African taxpayer, we can all appreciate that in such circumstances, a ship owner who has brought an individual into the country, an illegal foreigner that is, should bear the costs of repatriating that individual to his or her homeland. However, scenario B is somewhat different. Scenario B envisages a situation where an illegal foreigner already in the country illegally gains access to a vessel at a port in the Republic. So this is more commonly referred to as the trespasser situation. So what we'll basically be discussing today is the rights of a ship owner where he or she is faced with a situation where a trespasser has gained access to their vessel in the Republic. It will, of course, be necessary to deal with both scenarios A and B because the immigration authorities do have certain powers in respect of both scenarios, but particularly with regards to scenario A. Okay, so the immigration authorities derive their power from statute. They do not, however, derive their power from the Immigration Directive 9 of 2012, which they unfortunately seem to be relying on whenever they are faced with the situation of a trespasser. This document defines a stowaway as a person who, without permission, unlawfully boards a vessel at port of entry with the intention of traveling to a destination within or outside the Republic. Now that encompasses both scenarios A and B. The document is said to be for official internal use only, i.e. it's a directive from the department to immigration officials, effectively a directive or a memo from an employer to his or her employee. It has no force of law and has no application to third parties. The problem with this directive is that it purports to hold the ship owner responsible for the costs of repatriating an illegal foreigner, or as they define it, a stowaway, to his or her homeland, irrespective of where that individual gained access to the vessel. Okay, so looking at the concept of a stowaway, there's no legislation in South Africa that defines stowaways, and the closest thing we have to a definition is found in Section 317 of the Merchant Shipping Act. I'll be paraphrasing, and we are short on time, but effectively, no person shall go to sea or secrete himself on board a ship for the purpose of going to sea without the consent of the master, the owners, or a ship's officer. Where a person does go to sea without such consent, he or she is required to observe the laws and regulations pertaining to discipline as if he or she was a member of the crew. And where a stowaway has gained access to a vessel, the master of any ship shall report that to the proper officer at the port as soon as possible. So it's clear from Section 317 that there are no obligations imposed on an owner or a master to repatriate or detain a stowaway. So we'll have to look at the Immigration Act for proof of the powers conferred on the immigration authorities. Sorry, I'll be skipping through quite a bit, given the shortage of time. So Section 34 and 35, Sections 34 and 35 of the Immigration Act set out that a master of a ship or an owner are responsible for the detention and repatriation costs where they have brought an illegal foreigner into the Republic. So that's scenario A, discussed earlier. There's no provision in the Immigration Act for a situation in which a ship owner or master would be held responsible for the repatriation costs in scenario B. So what happens in reality when a ship owner whose ship is at Durban and who did not bring in an illegal foreigner has his vessel accessed by an illegal foreigner who had gained entry to the Republic via some other illegal means? Well, ordinarily, legislation provides that one must exhaust all internal remedies provided by statute before seeking recourse to the courts. So we look to Section 8 of the Immigration Act for the rights of a ship owner in such circumstances. Effectively, a ship owner would, when faced with a decision with which he or she disagrees, be forced to lodge an application to the Director General for the review or appeal of such decision. Unfortunately, no time period is set out within which the Director General has to make his or her decision regarding the review or appeal. So, if you're disgruntled with the Director General's decision, what is your recourse? Well, within 10 working days, you are then entitled to lodge an application to the Minister. Again, there's no time period within which the Minister is required to give his or her decision. We all recognize the commercial realities of shipping operations. They do not allow a ship owner or operator an indefinite period of time to await the decisions of the Director General or the Minister. They often have fixtures to meet, they have cargo which is sometimes time sensitive, and they simply cannot submit to the review and appeal procedures as set out in the Immigration Act. So, what other recourse do they have? Well, we have in recent times brought an application on behalf of a ship owner and the master who were faced with a directive from the immigration authorities that they detain and repatriate 3 individuals who had gained access to the vessel in Durban. Now, it was a fairly unique situation because the 3 individuals had gained access to the vessel in Durban after the vessel had been undergoing repairs for a period of almost 2 months. The vessel, luckily in those circumstances, was still due to be undergoing repairs for a further 3 or 4 weeks. So in that instance, the ship owners had the luxury of time. So we were able to launch an application to court, citing the Minister of Home Affairs as the respondent, on 3 days' notice, which is a requirement for any application in which the minister or any minister is cited as a respondent. And we were able to obtain interim relief. The interim relief effectively directed the minister to accept security. In that case, it was security by way of a club letter of undertaking for the costs of the repatriation of the 3 trespassers. The order directed further that the trespassers were to be removed from the vessel by the minister within a period of 24 hours after security had been provided, and that if the minister failed to do so, that the master was permitted to release the trespassers. The order further provided that the vessel was permitted to sail. So, notwithstanding the fact that it was still undergoing repairs for a period of time, the order provided that the vessel could, as soon as all other requirements were fulfilled, proceed to sail. The matter was ultimately argued a number of months later. Unfortunately, the wheels of justice sometimes turn quite slowly. But because the interim relief had been obtained, the vessel was free to sail unhindered. Ultimately, the matter was argued, and the determination was reviewed and set aside. A declaration was made to the effect that the master and owners of the vessel were not responsible for the costs of repatriation, and the minister was ordered to pay the costs. So what do we take away from today's presentation? Well, we can't completely ignore the commercial realities. As I've pointed out, ships are on a tight schedule, and owners often have to, unfortunately, bear the costs of repatriating such individuals, even in circumstances where they are quite confident that the individuals gained access to their vessel at a port in the Republic. But in certain circumstances where there's sufficient proof and sufficient time, the relief we managed to obtain for our client in this matter is certainly available to any ship owner, and we certainly hope that we could be of assistance if and when such an unfortunate circumstance does materialize.